Bismillah ar-Rahman ar-Rahim wa salatu wa salam ala ashraf al-mursaleen. We are going to proceed on page 202, and started, of course, commercial law for business students, for Al Isra University students, and starting on the title of Changing the Articles of Association. Changing the Article of Association. The articles may be amended by a special resolution. This must be put to the vote and requires a majority of at least 75% of the company's members. A copy of the amended articles must be sent to the registrar. Provisions in the articles may be entrenched, which provisions are not capable of amendment unless any conditions or procedures specified in the articles are complied with. Provisions for the entrenchment can be made in the articles before registration, or results from later amendment passed anonymously by the company's members, or result from a court order. The contractual capacity of a registered company. A company makes many contracts as part of the running of its business, and these are enforceable by and against it. In favor of a person dealing with the companies in good faith, any contract decided upon the directors should be deemed to be within the company's capacity. This meant that if a company was sued for breach of the contract, it could not use the ultra vires principle in its defense. Although this was a step in the right direction, it was having criticized. First, it was restricted to contracts initiated by directors, which in practice covers very few made by public companies. Secondly, it did not provide equal protection to a company which sued a defendant for breach. The defendant could still plead that it was not bound to perform the contract because it was ultra vires. Consequently, this point of view was amended so that the company should be treated as having the capacity to make any contract, even if it exceeds its object's clause. The good faith of the other party was irrelevant. Re-registering a company. It is possible to change the status of a company by re-registering it in accordance with the requirements of the law. This makes it possible to change a private company into a public or public one, and an unlimited company into a limited one, and vice versa. If a private company has done well and business is expanding, going public may be advantageous as it permits the company to sell shares to the public at large, thus making it easier to raise capital. This is the commonest registration change. A private company, limited or unlimited company, may apply to be registered as a public company limited by shares if its members have passed a special resolution to that effect, and it fulfills the minimum shares capital requirements. Application should be made to the registrar, including relevant accounts information and auditor's report, a copy of the special resolution, and a statement of the new name if relevant. If the registrar is satisfied that all the necessary requirements have been complied with, a certificate of incorporation or registration is issued. Buying a company off the shelf. Instead of going through the registration process, the promoters of a company may be a ready-made company from a business specializing in providing such a service. The seller registers companies and then renders them their document, relieving them of a duty to appoint auditors or prepare annual accounts. When the company is sold, the shares are transferred to the buyers, who then register themselves as the new directors and secretary. The name and objects of the company may have to be changed to fit the needs of the buyer's business. Apart from saving the promoters time and effort, buying a company off the shelf is generally cheaper than completing the registration process.